The employment rules in France are not at will and relies upon a huge and humongous labor code of something like 2,000 pages. Thus, dismissal of employees upon non-fixed terms agreement may only come about on sustainable and limited objective grounds, which must be brought to the attention of the employee in writing upon a 7 days prior appointment, then a formal interview, followed by a 2 days to 30 days bracket of time to notice the final dismissal. Dismissals are subject to stringent and often bureaucratic, procedural, statutory constraints. Furthermore, redundancy plans for layoff on economic grounds are subject to separate and complex procedural and substantive constraints, particularly in the case of multiple dismissal. There are a number of French state agencies which have a statutory right to be advised of, and in some cases to authorize proposed dismissal by private sector employers, especially for employees who have some representation or committee function. In fact, they are almost undismissible until the end of their mandate. One must bear in mind that it's extremely easy and virtually no cost for an employee to start litigation against his ex-employer before labor courts in France. Studies show that the mid-sized companies' financial exposure is much higher before labor courts than before commercial courts for commercial litigation. The labor court, Conseil des Prud'hommes, is a specific French jurisdiction dealing with labor law matters. Its bench is made up of elected judges from 2 electoral panels, representing respectively the employees on one side and the employers on the other. Its orders can be appealed before the Court of Appeal. It is rare that employees' claims are being dismissed with no award whatsoever being made against the employer, especially since some provisions of a labor code are set to the advantage of the employee only, as opposed to the employer would be applicable in respect of all contracts of employment. Even agreements in whatever language, drafted between parties, neither of which were French, that were made subject to an applicable law other than of France, might nevertheless be likely to be done under a construction wherein French public policy rules would prevail. In other terms, most of the employment agreement carried out in France by a French resident or French citizen are likely to be brought before the French labor courts. It is therefore crucial to take high care of the drafting of the employment agreements.